5 seconds to go. Start. In that context, it is clear that Section 17.4 contemplates that the declaration is to be made under Section 6 even when an urgency provision is invoked and an award under Section 11 is to be passed to determine the compensation. However, on a careful composite perusal of all the provisions noted above, it is evident that the requirement to tender and pay 80% of the estimated compensation before taking possession assumes significance so as to carve out an exception for non-applicability of lapsing as contemplated under Section 11A of Act 1894. This is so since the terms vesting absolutely and lapsing cannot coexist and cannot go hand in hand. Post amendment with effect from 24th September 1984, two elements have been inserted in Section 17 for the land to vest absolutely in the government for public purpose even before the award is passed. One is that possession should be taken. The other is by inserting subsection 3A, it has been made mandatory to tender payment of 80% of estimated compensation before taking possession. Therefore, 80% of the estimated compensation, the payment of which only if tendered and paid, the vesting would become absolute, and in such event, the consequence of lapsing in respect of absolutely vested land cannot occur, and as such, in that circumstance alone, Section 11A, though applicable, will not take effect. The right of the land loser would be to enforce passing of award, which will include the balance 20% of compensation even if it is beyond 2 years and get adequately compensated in terms of Section 23 and 34 of Act 1894 for the delay if any. But it is a different matter altogether when Section 17.1 is invoked, but the requirement thereunder, which is a prerequisite condition, is not complied. As noted, subsection 3A has been inserted with effect from 24 September 1984, whereunder it is made mandatory to tender and pay 80% of the estimated compensation before taking possession. Therefore, even if possession is taken, such possession cannot be considered as legal so as to vest the land absolutely if the prerequisite condition for payment of 80% before taking possession is not complied. In such circumstance, by legal fiction, it loses its character as an acquisition under Section 17, and since the absolute vesting does not take place, it will lapse if the further process is not complied and the award is not passed within 2 years from the date of declaration. However, even when the precondition is not complied, if the land loser does not challenge the acquisition and or taking of possession as illegal but concedes to the possession taken does not become per se illegal and the vesting will be absolute, and in such event it cannot be considered to have lapsed until the land loser exercises the right. We consider it so since both section 11A and subsection 3A to section 17 of Act 1894 were inserted in Act 1894 to enable the land losers to exercise their right conferred on them. Stop.